Republic vs. Jennifer Cagandahan, Gr. Number 166676, September 12, 2008. Facts: on December 11, 2003, respondent Jennifer Cagandahan filed a petition for correction of entries in birth certificate before the RTC, Branch 33 of Siniloan, Laguna. In her petition, she alleged that she was born on January 13, 1981 and was registered as a female in the certificate of live birth, but while growing up, she developed secondary male characteristics and was diagnosed to have congenital adrenal hyperplasia, which is a condition where persons thus afflicted possess both male and female characteristics. She further alleged that she was diagnosed to have clitoral hyperthropy in her early years and at age 6, underwent an ultrasound where it was discovered that she has small ovaries. At age 13, tests revealed that her ovarian structures had minimized, she has stopped growing and she has no breast or menstrual development. She then alleged that for all interests and appearances as well as in mind and emotion, she has become a male person. Thus, she prayed that her birth certificate be corrected such that her gender be changed from female to male and her first name be changed from Jennifer to Jeff. The RTC granted respondent's petition. Office of the Solicitor General filed petition in the Supreme Court seeking reversal of the ruling of the RTC. Issue: whether the trial court erred in ordering the correction of entries in the birth certificate of a respondent to change her sex or gender, from female to male, on the ground of her medical condition known as congenital adrenal hyperplasia. Held, no. In deciding this case, Supreme Court consider the compassionate calls for recognition of the various degrees of intersex as variations which should not be subject to outright denial. It has been suggested that there is some middle ground between the sexes, a no man's land for those individuals who are neither truly a male nor truly a female. The current state of Philippine statutes apparently compels that a person be classified either as a male or as a female, but this court is not controlled by mere appearances when nature itself fundamentally negates such rigid classification. In the instant case, if we determine respondent to be a female, then there is no basis for a change in the birth certificate entry for gender. But if we determine, based on medical testimony and scientific development showing the respondent to be other than female, then a change in the subject's birth certificate entry is in order. Biologically, nature endowed a respondent with a mixed, neither consistently and categorically female nor consistently and categorically male, composition. Respondent has female, 20, chromosomes. However, respondent's body system naturally produces high levels of male hormones, androgen. As a result, respondent has ambiguous genitalia and the phenotypic features of a male. Ultimately, we are of the view that where the person is biologically or naturally intersex, the determining factor in his gender classification would be what the individual, like respondent, having reached the age of majority, with good reason thinks of her sex. Respondent here thinks of himself as a male, and considering that his body produces high levels of male hormones, androgen, there is preponderant biological support for considering him as being male. Sexual development in cases of intersex persons makes the gender classification at birth inconclusive. It is at maturity that the gender of such persons, like respondent, is fixed. Respondent here has simply let nature take its course and has not taken unnatural steps to arrest or interfere with what he was born with. And accordingly, he has already ordered his life to that of a male. Respondent could have undergone treatment and taken steps, like taking lifelong medication, 26, to force his body into the categorical mold of a female, but he did not. He chose not to do so. Nature has instead taken its due course in respondent's development to reveal more fully his male characteristics. In so ruling, we do no more than give respect to, 1. the diversity of nature, and 2. how an individual deals with what nature has handed out. In other words, we respect respondent's congenital condition and his mature decision to be a male. Life is already difficult for the ordinary person. We cannot but respect how respondent deals with his unordinary state and thus help make his life easier, considering the unique circumstances in this case. As for respondent's change of name under Rule 103, this court has held that a change of name is not a matter of right but of judicial discretion, to be exercised in the light of the reasons adduced and the consequences that will follow. The trial court's grant of respondent's change of name from Jennifer to Jeff implies a change of a feminine name to a masculine name. Considering the consequence that respondent's change of name merely recognizes his preferred gender, we find merit in respondent's change of name. Such a change will conform with the change of the entry in his birth certificate from female to male.